Committee on Investigations here on Friday, February 13th, 2026. We had our subcommittee meet this morning, the Dolezal Subcommittee, and many of you may be aware that we had subpoenaed Nathan Wade, and I think Jeff DeSantis has also agreed to accept his subpoena electronically. They are both represented by counsel, and they have asked for a delay in their testimony. Our counsel, committee counsel, Josh Belinfante, has been negotiating with their attorneys for a convenient date that works both in our schedule and gives them adequate time to be prepared for their testimony here. We anticipate that that will be in the next couple of weeks, 2 to 3 weeks, as they work out terms and conditions for that. On the bright side, they have been served with subpoenas or accepted the subpoenas, and they acknowledge the validity of those subpoenas. That we do not anticipate that they will file any motions to quash or tie us up in court, but we're working cooperatively with their counsel to try to arrange appropriate times and conditions and limitations on their testimony before our committee. So that will be coming up in the near future. In the meantime, the full committee will also be continuing to hear testimony. And I would anticipate, like we have talked about previously, that many of those meetings will be on Fridays. The reason for that is because the legislature is often off on Fridays. We have committee work days sometimes, or just days off. And then when we are in session on Fridays, there are no scheduled committee meetings on the Senate side. And we normally adjourn sometime close to noon, and that gives us those afternoons where we can make some progress with our activities here. I anticipate that we will hear from some district attorneys or their organization, and from state court solicitors and other angles that we need to get the full picture of all sides on the prosecutor's point of view. On a lot of matters, some, of course, the standards of conduct that we've been looking into, but also District Attorney Willis raised some financial concerns as to whether or not we're adequately funding our prosecutors in this state. And so we're going to get some feedback from prosecutors on those type of actions and whether or not we're adequately funding them to do their jobs, and their views on what are the appropriate guardrails or guidelines or rules of conduct, so that we have clarity on that. We also were charged with looking into some of the campaign finance violations from the New Georgia Project and other groups that are acknowledged and admitted, and to take a look at what we can do to ensure compliance, fair disclosures, transparency in our campaign finance laws. So we will continue with meetings as the winter proceeds, and kind of on a dual track, because we are proceeding under two different resolutions that gave us our authority. For committee members, I'm going to tell you now, I am going to try to schedule a meeting on next Friday, February 21st. And very likely will be also a meeting on Friday, February 27th. My preference would be to have those begin just upon adjournment of rules, or say 30 minutes after rules. For those in the public, it's very difficult for us to know what time we're going to adjourn. Yesterday we had a 6-hour debate on tax policy, and many of our committees got canceled because the debate stretched into the scheduled meeting time. So we don't know how long we'll be in on those Fridays. Most Fridays we start a little bit early and have a limited calendar as people try to travel back to their home communities. So I can't give the public or the press any better indication of what time those meetings will start, but we are going to be looking at those next 2 Fridays for sure. I wanted to get an overview of where we've been and where how we're doing, and I've got a very able and technologically adept counsel, Mr. Josh Belinfante, that has helped review a little bit of what we've done, what our charge is. But I would remind you, this has been going on for a couple of years, and we've now received testimony from quite a few witnesses, various prosecutors, including District Attorney Fonnie Willis. We've had folks that have complaints against her office that have been here. We've had other prosecutors give us their views on things. We've had defense counsel in some of the election interference cases testify, and we've been gathering kind of all the facts and figures that we need to do our job to try to restore public confidence in our criminal justice system. At this time, I'm going to turn the floor over to you, Mr. Belinfante, and if you would walk through with us your summary. He's done a very nice sort of slideshow, whatever you call it now, your PowerPoint deck. I'll turn him on and let him talk for us.
All right. Well, thank you, and I'll try to be pretty quick. Starting with the authorizing legislation going back to 2024, which was the basis of the first subpoenas that led to the litigation. As an update on the litigation, I think as everyone knows, both we and opposing counsel said at the Supreme Court that if the district attorney comes and does testify, there would be nothing left for the Supreme Court to decide. We both then later represented that to the Supreme Court after the December 17 committee hearing, and the court dismissed the case as moot. So that is now done. Senate Resolution 465 charges the committee with investigating several things, including various forms of alleged misconduct relating to the prosecution of cases by the Fulton County District Attorney of cases related to the 2020 presidential election, but also matters of appropriations and determining the method in which district attorneys are funded by the state, public confidence in criminal justice, and other matters to determine if there was a need for additional or amended legislation. Senate Resolution 5 more or less adopts the same charge, and Senate Resolution 292 added the campaign finance piece that you discussed. Each of the resolutions calls for the possibility of a committee report to include findings of fact and potentially recommendations on the need for legislation and/or appropriations reform. There are several issues that I think have come up just during the various court cases that have occurred and also during committee testimony. I'll go through some of those here. These are not the only ones, but there's questions that have been raised as to whether Georgia prosecutors should be held to a higher ethical standard than attorneys representing civil and private clients. How do you define conflicts of interest in criminal prosecutions, and particularly political prosecutions? The appearance of impropriety, which was a large part of the State v. Roman decisions that went up to the Supreme Court of Georgia, using special assistant district attorneys, and the campaign finance and independent committees. I know the committee has also expressed interest in looking at things like special grand juries and statewide grand juries, and appropriations, forfeiture funds, the use of forfeiture funds, and other forms of compensation for district attorneys' offices. We spent a lot of time, and I think from what I have learned in talking to members of the committee, you know, a lot of this does center around a significant amount of litigation in Fulton County, but also through the testimony that was there, it became clear that Fulton County just does things differently sometimes. And so while this is focused on the Fulton County prosecution, it has raised issues that are and can be addressed by general law and state law should the General Assembly choose to do so. There are really two sources of some of the issues. They were both recusal orders. The first is a conflict of interest that was found in May 2nd of 2022, which recused the Fulton County District Attorney from investigating then Senator Burt Jones. And in September of 2024, PAC had reviewed it, met with the then Lieutenant Governor, I think 2 or 3 times, accessed cell phone, and found that there was nothing to investigate. On the appearance of impropriety, that's the one with the remaining defendants in the 2020 election case. The trial court order came out on March 15 of 2024, demanding that either the Fulton County District Attorney or her Special Assistant District Attorney recuse from the case based on an appearance of impropriety. There was no finding of a conflict of interest. It then went to the Court of Appeals because the defendants appealed it and said that the remedy was insufficient. 2 of the 3 judges on the panel agreed and said it was an abuse of discretion because the trial court's order did not provide a remedy for decisions that were made early in the case, who to charge, what to charge them with. And the Supreme Court of Georgia denied certiorari in a very split opinion, saying that they were not there, and this is the Supreme Court standard, to simply correct legal error. It had to be something that would repeat itself, and the majority found that that was not the case. Looking at issue number 1, is there a higher ethical standard for prosecutors? The district attorney argued to the Supreme Court in asking them to take the case and review it on appeal that no Georgia court had ever identified or applied a standard unique to prosecutors. Justice Pinson, writing for those who voted to deny cert, disagreed, said that the argument is not without force and finds some support in the language of our earlier decisions. A lot of those decisions were cited in both the Court of Appeals opinion and also the trial court's 2024 decision as well. So if the committee were looking at things, for findings of fact, I think it's fair to say that the Court of Appeals decision is new precedent. It does clarify, even on a divided panel, that there is a higher standard for prosecutors, and there is no statute that addresses that or identifies it. Now, normally, the legislature, it has been decided by the courts, does not have the authority to regulate the practice of law, that comes under the judicial branch and the State Bar of Georgia. District attorneys, however, are unique under our Constitution. There are 2 provisions that give the General Assembly the authority, express authority, to decide by general law what are the other duties of district attorneys. And the General Assembly is expressly empowered to decide how to discipline, remove, or involuntarily retire district attorneys, which is part of the litigation that is ongoing now, where some district attorneys have challenged the Prosecuting Attorneys Qualification Commission. Much of that litigation centers around these 2 provisions. So if the legislature were to consider this issue of whether to impose a higher ethical standard, I would suggest that it has the express constitutional authority to do so. The second issue are conflicts of interest, and really in political cases. Some conflicts we have very well settled law. Someone who had been actively involved in the prosecution of someone cannot then go into private practice and represent that same person in a case, and or vice versa. That's a very clear one, and there's a fair amount of body of law on some of it. It is harder when you get into some of the issues that were raised in both the recusal order, the first one, and whether there was a conflict. Judge McBurney said there was a clear and palpable conflict, and I'll get into why he said that and what he was discussing. But in the second one, done by Judge McAfee, there was no finding of conflict. The problem with political cases, and this is the committee's charge, is most polling that I've seen recently, and going back 4 or 5 years, is showing a waning public confidence in the criminal justice system. I think the members are certainly aware that folks on all sides of the political spectrum believe that there has been, quote, lawfare and or witch hunts, and that prosecutors' offices, not unique to Georgia, not unique to states, are being used in political prosecutions. The Roman case, this is the Court of Appeals decision ordering full recusal, talked about how the broad pretrial discretion that district attorneys have can lead to those concerns. It's not just what happens when you get there, but it's those decisions about who to charge and what to charge them with. Justice McMillan wrote for the dissenting justices, who wanted to grant cert of that decision. And she expressed concern that if this is a new standard in terms of the appearance of impropriety, there could be a chilling effect on legitimate prosecutions, particularly of political and or elected public officials. And so the law is certainly a bit new on that. because we just don't have much of it in Georgia. The issue and how it arose here in the Judge McBurney order is the campaign of then Charlie Bailey for lieutenant governor in the 2022 election. The timing of such was that after he was in the runoff, the Democratic primary runoff, and before the runoff concluded, District Attorney Fonnie Willis headlined a fundraiser for him, used her title in doing so, and that is not unusual for elected officials to do, including district attorneys. The problem was, according to Judge McBurney, was that she was also she had sent subpoenas to then Senator Burt Jones, who was the Republican nominee having won without a runoff. So you had a situation where the district attorney was campaigning for someone who was going to be running, at least potentially at the time, running against someone she is investigating. And as Judge McBurney also pointed out, Mr. Bailey was running against Mr. Jones for things that were being brought up in an investigation by the Fulton County District Attorney. And so it gave the appearance, he said it was a complete conflict because it made it where if the district attorney went easy on then Senator Jones, it would be because she felt she had to compensate for this. If she went hard on him, it would appear because she was trying to help the person she had endorsed in the race. That was the basis of that one. There was also Chairman Dolezal in the December 17 hearing walked through largely a timeline of the larger prosecution and what occurred after that. I won't go through all of them, but the short story of it is that there were various conferences known through documents that have been made public here and in other forum where the Fulton County prosecution appeared to be working with White House counsel and or congressional committees at the time who were also investigating the 2020 election and its aftermath. I think the key important points there are on 9 November when President Biden stated in a public press conference that they needed to make sure he, referencing President Trump, under legitimate efforts of our Constitution, does not become the next president again. And then 6 days later, President Trump announces he will attempt to seek re-election. And then the next day, the billing records from the Fulton County prosecution show an 8-hour January 6th meeting. And the day, 2 days after that, 3 days after President Trump announces his re-election, there's another D.C. White House interview between the Fulton County Special Assistant District Attorney on the case. That same day, Jack Smith is appointed independent counsel, and at or around that time, Matthew Colangelo resigns as effectively the number 3 at the Department of Justice and goes to the Manhattan DA's office where he works on the prosecution of President Trump there. And so the timeline, I think, has spoken to what the Senate resolution has pointed out as concerns of political prosecutions, waning public confidence, as it appears to be all coordinated and stemming from, or it could be argued that it appears stemming from that November 9 statement. So there could be, if the committee were looking at findings of fact, there's, I think, a good deal of data supporting that the public is concerned about politically motivated prosecutions. I think it's well known that President Trump has described a lot of the investigations of him as a witch hunt. Governor Barnes said that when the district attorney was here that she was being part of a witch hunt. So it is clearly happening on both sides. There's no law in Georgia that addresses conflicts and impermissible considerations, where you do have that in other states, and I'll get to some other ideas on it. And you also have no law that addresses, at least explicitly, the political activity of employees in district attorney's office. And Chairman Dolezal, I know you had asked questions where the media relations deputy district attorney in the Fulton County office was a campaign officer of at least one of Mr. Bailey's campaigns. It was when he was running for Attorney General before he ran for Lieutenant Governor. but also other political activity and working on candidates, and whether there should be consideration of addressing that. The finding of fact could be we really don't have any specific law on it. Congress has required, in their response to these kinds of things, really after Watergate, the Department of Justice to promulgate regulations and address when there could be conflicts other than the traditional type. The Department of Justice has promulgated a significant amount of regulations or policies talking about inappropriate considerations when deciding who to charge and what to charge with, ranging from race, gender, religion to political affiliation, et cetera. The American Bar Association has also published what they call guidance or aspirational rules that effectively say things very similar to the U.S. DOJ. I think the ABA goes a little further and talks about prosecutors should not use prosecutions as a means of advancing their own careers or enhancing their public image itself. So there are sources, if there were to be an interest in having legislation on this issue, that certainly the General Assembly could turn to, and that's before even getting to other states. And again, here I think because of the express constitutional authority, it would be within the General Assembly's purview to do so. Third is the issue in the second recusal order, which is the appearance of impropriety in criminal prosecutions. Judge McAfee said that there was an odor of mendacity, even though he found there was no conflict of interest, that the appearance of impropriety is what led him to order a remedy. Again, the Court of Appeals picked up on that language and said that there was a significant appearance of impropriety as a finding. Part of that case and the way it got to the Court of Appeals, the District Attorney's Office had not challenged that finding of fact. So the Court of Appeals, it was a rare situation where they were considering it where there was an undisputed appearance of impropriety. And the Fulton County District Attorney's argument was effectively that an appearance of impropriety standing alone was not enough to mandate recusal, that you needed to show actual prejudice or an appearance and a conflict of interest. And there was, again, no finding of conflict of interest in the case. Justice McMillan's dissental walks through and very strongly dissents from the Supreme Court deciding not to review the Court of Appeals decision, and concluded that the state of the law is confused and conflicted. And the basis of that that she cites and others have too really comes from, I believe it was 2002, the State Bar, with the approval of the Supreme Court of Georgia, revised our model rules of professional conduct. Prior to that, there had been what was called Canon 9. Canon 9 said that there is a basis that attorneys should not engage in representation if it creates an appearance of impropriety. Many states found that that was very difficult to define, to apply. Georgia's State Bar and judicial leadership apparently agreed because Canon 9 did not make it into the new version of our State Bar rules. And so a lot of the debate between both Justice McMillan and others and between now Justice Land and the two judges in the Court of Appeals case is should they be relying on cases that cited and or relied on Canon 9 when talking about an appearance of impropriety. The trial court's order, I think, correctly recognized the first thing you'd have to do is define it, and he offered 3 definitions from legal dictionaries and precedent. And then the question is, if you find an appearance of impropriety, what is the appropriate remedy? Is it mandatory recusal? Is it possible recusal? Do you need to show prejudice as well? And that area of the law, if you were looking at a finding of fact, is not defined in statute, and it's not particularly clear here, and there is no rule of professional conduct that addresses appearance of impropriety, and certainly not one that is unique to prosecutors. So looking at potential legislation and providing, frankly, just clarity for judges, for prosecutors, for criminal defendants, what is the status of the appearance of impropriety as a standard, and then The congressional approach has been to require the Justice Department to create its own standards and require policies and procedures. I think the General Assembly could do that as potential legislation as part of the duties of district attorneys, require them to promulgate their own policies.
Do we have those through, you referenced American Bar Association rules? Do they more clearly define what the appearance of impropriety would be?
They're not, I don't believe they're as clear on that. I'll need to double back because I've looked at those on the political prosecution and improper motivation.
How about other state laws? I need you to take a look at other
Will do.
states if they more clearly define it, because I'm hearing that from all interested parties, both the prosecutors and the public, that it's an issue that needs some clarity.
And in many states, and I think this was in Justice McMillan's dissental as well, have moved away from appearance of impropriety as a standard. When Canon 9, they had similar ones there. And then I think, if the General Assembly is going to decide to go down the road, it would be, I think, beneficial and clarify what is the procedure for raising allegations of an appearance of impropriety. Justice McMillan also cites this in her dissental. Do you have to wait until after verdict? Can you do it before? Can you do it during? How would it be appealed? All of those questions. And again, trying to balance that need to maintain the integrity of the prosecution while at the same time not chilling legitimate criminal prosecutions. The next one was the use of special assistant district attorneys. In most jurisdictions, the committee heard testimony that is a rare thing. If they do use a special assistant district attorney, they're typically another assistant DA from a separate county or office, and rarely are folks gone from outside to do so. The General Assembly has passed legislation dealing with special assistant district attorneys within the last decade or so. Specifically dealing with hiring a special assistant district attorney for forfeiture based prosecutions and seizing of property, and then being paid on a contingency basis of the value of that property. The legislature prohibited that practice because it was determined that it leads to perverse incentives where you're really not seeking to do justice but raise the value of whatever you're seizing within that process. So in looking at that, the role of special assistant district attorneys, there's a statute, does not exactly mention it, and that statute really talks about assistant district attorneys. It's been through case law that we've seen the courts have decided that district attorneys have the inherent authority to retain counsel to assist them in prosecution. But they are different from assistant district attorneys, which are employees of a district attorney's office, versus a special assistant, which is a contractor. The scope of representation, the courts talk about special assistant district attorneys typically being hired for a case, as was the situation in the Fulton County election litigation. It was also the case in the Fulton County prosecution of APS. Versus an ADA who will work on cases across depending on how the district attorney organizes the office. And also the role of county governments. When a special assistant district attorney is appointed, the county government is not required to approve the district attorney's use of that, whereas if they exceed the minimum amount of assistant district attorneys provided in state law, the county has to approve of that, which is we saw and heard from Fulton County on that issue. And then because most of this is in case law, there are no guidelines on the use of special assistant district attorneys, how special assistant district attorneys prosecute, what their billing is, et cetera. And the Fulton County District Attorney brought up the issue of, when she was asked about this several times, of Special Assistant Attorneys General, or SAGs, who work for the law department as an extension of the Attorney General's office. Unlike special assistant district attorneys, SAGs have two statutes that authorize the Attorney General to appoint them. Their role is by case, although sometimes you will have SAGs that say represent various, some number of defacts cases in a particular county, or they represent the DOT's condemnation in various areas. SAGs are also very transparent, as those who saw on December 17 got to see. The Attorney General publishes a guide every year showing, identifying the name of the SAG, identifying how much was paid to that SAG for a particular case. Now, I will say that the way the Attorney General has published it, and this has been the case since at least 2013, it identifies, because one person is a SAG, but the practice is that that money goes and is paid to the law firm. So it's not as if every person there you're seeing is making what it is shown. And actually, that was similar to the use of the special assistant district attorneys in Fulton County, and there was a lot of testimony about that before the trial court. So it is more transparent, and there are pretty extensive guidelines that the law department imposes. No block billing. You have specific rules on conflict of interest. You have specific rules about speaking to the public. SAGs are not allowed to comment to the press, and all of this is in a pretty lengthy contract or provision that is available online at the Attorney General's website. So what we know about special assistant district attorneys, if you're looking for findings of fact, is that there's limited statutory law, and it is unclear what the appropriate funding sources would be for an SADA, because you don't have the same restrictions that you do with assistant district attorneys.
Let me stop you there, because my recollection of the testimony was that Fulton County funded special assistant DAs to assist Ms. Willis. That's not funded by the state of Georgia?
No.
Right, okay.
No.
So that's county by county if they decide to provide enough in the budget for that type of prosecutor?
It is, but because the county can't, the special assistant district attorney can be appointed without the approval of the county. It comes into kind of general office. I think we heard the district attorney was not sure which pot of money was used in various ones. Were forfeiture funds used, and what was the appropriate source?
Okay.
And just didn't know. If you're looking at potential legislation, just codifying what to do if there was an interest in doing so with special assistant district attorneys. And again, most jurisdictions, the vast majority do not use SAD as much, and they typically come from other districts. Billing procedures was raised as an issue, conflicts of interest, apparently twice, sorry about that, and funding sources as well. And then moving on to the last, and again, there are others I know that the committee has expressed interest in and will continue to do, but the last one would be campaign finance and independent committees. You heard from the executive director of the State Ethics Commission the distinction between candidate committees and independent committees, that independent committees can engage in express advocacy, the vote for, vote against language. Although in 2017, the Ethics Commission issued an advisory opinion saying that even if something were not express advocacy and therefore not an independent committee, it could be an in-kind contribution to a candidate committee and subject to caps. And that gets into the question of coordination and those in-kind contributions, but there is not a lot of statutory law on that. The sources of independent committees, their role, their limitations, and coordination is really not in the Ethics in Government Act. It is in advisory opinions and the Ethics Commission's rules, as well as judicial decisions, which have recognized how the Commission does interpret that. The potential findings of fact could be certainly that the role of independent committees are increasing. No secret there that campaign finance law has changed dramatically in the last decade or so, since there was a major overhaul of those provisions. The Supreme Court has found a more robust protection of free speech than it had previously. And there's also been administrative law changes here in Georgia where agencies promulgating regulations are not given the deference that they once were, and highlighting the need potentially for statutory law. That statute could clarify what is an independent committee, what does it do, when does it have to register, can they engage in in-kind contributions? If so, what does coordination mean? The federal government and the FEC has a lot of regulations on coordination, everything from if you work for a campaign, you have a cooling off period before you can go to an independent committee and vice versa, to how you construct firewalls between the two. And then also streamlining the process, because I think what you heard about in the New Georgia Project is that by the time the group was before the commission again, it had spent all of its money except that used to pay the fine. And so if the commission can't act quicker or put freezes on things, that could continue in the future. And
Yeah, that bothered me that there's basically nobody there to prosecute. If you violate those rules on coordination and essentially circumvent campaign finance law, or, as to the amount of contributions, election's over, it's an organization, people are gone. I don't know how you hold them accountable, because unless you do hold them accountable, there's no deterrence for that type of conduct. We'd love your input or insights, and let me know what other states may be doing in that regard.
we'll do.
Okay. Any committee members have questions for Mr. Belinfante? He's done a pretty comprehensive review of where we've come so far, the issues that we pointed out, and suggestions for areas of new legislation.
I did have one, Mr. Chair, and that was.
Senator
When you were
Jones,
saying
you're
that the-
recognized. Go right ahead.
Thank you. When you're saying that the General Assembly could have some type of restrictions on the DA or prosecutors, the involuntary retire, I think, was one of them.
Mm-hmm.
Would that be after that that process was the commission, or would that be on our own?
It just says you can provide by general law
Okay.
the procedures to do it. So in the case involving the commission, that's the defense for the commission's authority, is that you have created a general law to do
Okay.
so. And that would be, I think, the answer to that.
Okay, thank you.
We have a few members that are not here today. I want to point out that Senator Blake Tillery is chairman of our Appropriations Committee, and I think Senator Steve Gooch is also on that committee. We've got two committee members here that did show up, Bo Hatchett and Greg Dolezal, who have subcommittees on our appropriations. Their presentations are not at this time, or you guys made excuses to get over here, but our other members are active in the budget process. It's called the Green Door Committee, which is a meeting of the different subcommittee chairmen of appropriations, are all sorting through the supplemental budget today, so they're not here, but we'll educate them later, let them have your slideshow and get any input they have. I would invite all committee members within the next week, if you please will, to present any suggestions or ideas for legislation addressing any of these issues or others within the scope of this committee. I will plan to meet next Friday upon adjournment of the Rules Committee, which is directly after session adjourns. I think it probably would be too quick to get the cooperation of Wade and DeSantis by that time. We're going to need to let their counsel get them prepared and negotiate the terms of their appearance. I'm going to try to get somebody from the district attorney's organization and the state court solicitors organization so we can get their feedback on a number of these issues before we move forward with legislation. But tonight, I'm sorry. I'm going to recognize Senator Dolezal for a couple of questions for you, Mr. Belinfante.
Thank you. Josh, on an early slide, you had something on, and you referenced, I believe you said the bar had rules around taking clients for some sort of personal benefit. And I forget the exact language that you used.
It was, if I remember, if there's a ABA, I think it was out of the ABA's guidance, it may be in the Justice Department too, about when prosecutors should not take on a case to further their own career. I mean, I think all of the discussion from courts, from former Attorney General Jackson, whose quote is used by everybody, is that prosecutors have a unique role. It's not winning or losing, it's seeking justice. And so, given that authority, that was kind of the basis of that concern.
And the state law is silent on that. I'm what wasn't in the timeline that you went through that I think relates to this, that the committee, Mr. Chairman, should consider is the fact that immediately prior to sending the document retention letters to Governor Kemp and Secretary Raffensperger, we know from emails that internally the district attorney's office was setting up the mechanisms by which they would begin to track the dollar value of her earned media. We know from other internal documents that came through that that dollar value was over $600 million. And so I am wondering, and we can maybe have this in a follow-up committee, I'm wondering whether state law needs to undergird that ABA rule in a more substantial way, because you certainly can argue that that is a quasi in-kind campaign contribution when you're seeking kind of earned media. The second question I had, you had the slide up in terms of recommendations around the use of funds, and I know that you referenced the district attorney was unaware of the use of her funds. Well, we know from the accounting receipts that forfeiture funds were used to pay Mr. Wade. Regardless of whether she was aware of that or not, we know that from the exact accounts that were used. Can you shed a little light on your understanding of what state law currently has as it relates to the commingling of state and federal funds, specifically state and federal forfeiture funds? And then secondly, what either one of those laws may say about the use of those funds for contracted positions?
My understanding is that the federal regulations and guidance and statutes on forfeiture funds require them to be separate from state funds so that they can be traced and followed, because the feds put a fair amount of restrictions on how they're used. The bulk of forfeiture funds in most district attorneys' offices are state forfeiture funds, because the federal ones get spread across the country. So there's just less of them. There is not a lot. There's a good deal of statutes on how forfeiture funds can be used, and specifically how special assistant district attorneys cannot be compensated on a contingent basis for forfeiture funds. But some of it is relatively new, and by that I mean 4 or 5 years ago, and there's been some case law developments on it. So in conversations preparing for committee hearings and whatnot that I know have occurred, there's not a unanimity of opinion on how, when you get into very specific questions about how forfeiture funds are to be used. There's broad consensus on, certainly some most of the issues, but there's not. There are specific questions about how and when they can be used related to types of prosecutions, and whether forfeiture funds, even within a district attorney's office, how those to be used as well, because it could create an incentive. And there was a discussion about when the budget starts to get thin, they go find more property to seize and use it as forfeiture funds to make up for shortfalls in the budget.
If you don't mind going, I've got one last question, Mr. Chairman. If you don't mind going back to your presentation, and if you can go to the timeline slide that you had.
This one?
Yeah. So when D.A. Willis was here, one of the things that was more interesting to me was specifically beginning November 9th, when President Biden stated that essentially they needed to ensure that President Trump would not take power. A few weeks after that, a week after that, President Trump declares he's running for election. We then know from the billing records that Mr. Wade had an 8-hour J6 meeting. We don't know what that is. We'll obviously ask him what that is. We know that from his congressional testimony that he doesn't remember that, nor does he remember spending 8 hours at the White House just a couple of days after that, or in D.C. /White House interview. I guess we don't know whether he was there or not. I'm wondering if we need to look at some guidance for our prosecutors relative to there's two separate things. One, I would say that this concept of an 8-hour phone call doesn't really pass the smell test, and there's a number of these 8-hour phone calls in these bills. In addition to the forfeiture funds, obviously we know that taxpayer funds were used in the payments. We know that from the accounting records. But the second piece that's interesting to me that I think that would be interesting for the committee to contemplate is what appears to be, and what's not on here, I don't think, is the Athens meeting as well, which I think
that was the May
that's
22, the first one.
I missed that one. Okay.
Yep.
So the Jan 6 and witness prep was in Athens.
The conference with White House counsel on May 23rd, I believe, is the one that was
Got
in
it.
Athens.
Okay,
And
so
then
that's the
there was
May-
a follow-up on that, and that was right before the special purpose grand jury began to hear evidence.
And as I recall from his congressional testimony, Mr. Wade doesn't remember anything about any of those 4 meetings. Is that your recollection from the
That is my recollection.
testimony as well? So I've got questions around the use of taxpayer dollars as it relates to the billing. I think that we would all agree that that was very, very, I'll charitably use the word unique billing practices that were used. We know that it differed from the other special assistant district attorneys that were working on this case. But also this White House coordination is something that I think that the general public has questions about, and I don't know what we could or could not put into state law as it relates to the coordination of federal and state prosecutions. And there may not be anything there to that. There may be something significant there to that. Obviously, we'll hear that in testimony. But I just wanted to flag that, Mr. Chairman, for your consideration.
That gives me thoughts as well, Mr. Belenfante. On this timeline, can you edit that or expand that? You just mentioned when the special grand jury was impaneled.
Yes.
Show us the timeline of that. I believe that required approval of the superior courts before they could do that, and when that approval was obtained, when the grand jury was impaneled, you show there when the report came out. And then I'd like for you to continue it forward, because after that report came out, it was quite some time before indictments were ever returned. So I'd be interested to know when the grand jury that issued the indictments was impaneled and when the indictments were issued by that panel.
I can tell you right now, but
I'm interested now,
Okay,
but
yeah.
I want you to put it on.
I'll put it there,
For
yeah.
visual effects on that as well, because this timeline is significant when the
So the Fulton County Superior Court convened the special grand jury on January 24 of 2022. It did not begin receiving evidence until June of that year, and there was discussion in the first recusal order that was done in part because the district attorney did not want it to interfere with the primary that year.
which primary are you talking about?
The statewide primaries, including the lieutenant governor's race that led to the recusal order. The special grand jury was dissolved on January 9, 2023, and the indictments were secured on August 14 of 2023.
So it was 8 months later, after the report and everything had been done. You show it was December 15th was the report.
Yes, that's when it was submitted to the judge, and
So it was 9 months later before they were, actually indictments were made.
right.
Okay. Let's make sure we obtain a copy of that grand jury report for the record in this committee's records. Can you obtain that for us, or should I use other Senate research or somebody else?
I'll if I can't, I'll let you know.
Okay.
I think a lot of it
If
has
it's
been
convenient
made
and you
public.
have it, if you would provide that to me, I'll put it in the record, because that's part of the contention is the unique nature of this. It is an election interference indictment, and the conduct of the DA and the timing of all this is claimed to be election interference by President Trump. So we'll flesh that out. And anybody else have other ideas for legislation, let us know. And you members have got to get back to appropriations, try to keep our budget balanced as always, and good luck to Senator Gooch and Senator Tillery that are hard at work over there. Thank you. With that, we are adjourned.